Judgment in the appeal, the Queen on the application of Nouazli and the Secretary of State for the Home Department.
Mr. Nouazli is an Algerian national. He entered the United Kingdom in March 1996 using a false French identity card, and he worked as a barber. He applied for asylum, but this was refused. Shortly afterwards, he married a French national who was working in the United Kingdom, with whom he had 2 children. He was granted a 5-year residence permit as the family member of a European Economic Area national, which was renewed until 2004. By February 2003, he had acquired a right of permanent residence in the United Kingdom under European law. But from 2001, his wife had become depressed and became involuntarily unemployed, and he had begun to take drugs and drink. Their children were taken into care, and by July 2004, the couple were estranged. She returned to France in late 2005, and the 2 older children were transferred into care there. Mr. Nouazli then embarked on a pattern of offending, which saw him convicted 28 times for 48 separate offences by the end of January 2012. Those offences included theft, possession of controlled drugs, affray, possession of a bladed article, and other non-custodial sentences for motor vehicle offences and various acquisitive and drug possession offences. The Home Secretary tried to deport him in early 2007 because of this offending, but she was unsuccessful. Mr. Nouazli continued to offend and was sentenced to 20 weeks imprisonment for an offence of theft in early January 2012. Just as he was about to be released, in April 2012, the Home Secretary served him with a notice of her intention to make a deportation order against him on grounds that he would pose, quote, a genuine, present and sufficiently serious threat to the interests of public policy, end quote, if he remained. Removal on these grounds is permitted under Regulation 19.3b of the Immigration European Economic Area Regulations 2006. He was then detained under Regulation 24.1 of those same regulations, which permits detention if there are reasonable grounds for suspecting that a person is someone who may be removed under Regulation 19.3b. He was detained pending a decision being made on whether, in fact, to deport him. Mr. Nouazli applied for judicial review of that decision. He argued that his detention was unlawful and incompatible with European Union law in that it discriminated against him on the basis of nationality, contrary to Article 18 of the treaty. He said that this was because family members of non-EEA nationals or British nationals cannot be detained pending a decision being made on their removal, whereas family members of EEA nationals can be so detained. The upper tribunal dismissed his claim, and the Court of Appeal dismissed his appeal from that decision. Mr. Nouazli's appeal to the Supreme Court raises 4 main points. First, does the power to detain under Regulation 24.1 discriminate against EEA nationals and their family members? Second, is that power unnecessary and disproportionate? Third, is the absence of any specific time limit for such detention contrary to European Union law? And finally, do the regulations fail accurately to transpose the safeguards in the Citizens' Directive on which the regulations are based? Today, the Supreme Court unanimously dismisses Mr. Nouazli's appeal and hold that his pre-decision to remove detention was lawful and compatible with European Union law. The only judgment is delivered by Lord Clark, who cannot be here today because of judicial duties in Hong Kong, and all the other justices on the case agreed with him. Firstly, the power to detain pending a decision on deportation does not discriminate against EEA nationals and their family members. European Union law is mainly concerned with the way in which European Union citizens are treated in member states other than their states of nationality. It is not concerned with the way in which member states treat nationals of countries outside the European Union who are living within their territories, as in this case. Nor does Regulation 24.1 discriminate between British nationals and EEA nationals who each have third country spouses, on the basis that the spouse of the EEA national might be deterred from exercising his or her own free movement rights. Here, Mr. Nouazli had been estranged from his wife for a long time, by the time of his pre-decision detention, and she is unlikely to have been deterred from exercising her rights because of it. Secondly, the power under Regulation 24.1 is both necessary and proportionate. No one has contended that the power was applied disproportionately on the facts of Mr. Nouazli's case. Thirdly, the absence of a fixed time limit for pre-decision detention under Regulation 24.1 does not infringe the so-called Hardial-Singh principles. The Hardial-Singh principles require that people are not detained for deportation beyond a reasonable time, but that does not mean that there have to be fixed time limits on their detention. Fourthly, and finally, the Court is not persuaded that Regulations 21 or 24 fail accurately to transpose the safeguards in Articles 27 and 28 of the Citizens' Directive. They are compliant with the directive. So the decision to detain Mr. Nouazli with a view to his removal to Algeria was lawful.